first instance under the complaint, the findings was there was a concern over the lack of notice given to the public for the closed session and the timing. And while I found it had merit, I wanted to be careful because it was abundantly clear in the investigation that there was no intention to conduct a closed session when the agenda was prepared and delivered. It wasn't. It was very, very clear. We spoke to staff, we spoke to it was a spontaneous event that happened. And from my point of view, when I go back and link it to the requirement of a local board and the procedural bylaw, I concluded that there was no effort really to consider an amendment at the time of the meeting during the course of the discussion of this thing to amend the agenda to actually have a good discussion about the merits of going into a closed session. It wasn't. The committee simply moved into closed session, and I'll speak a little bit more about that. The next concern was lack of proper resolution. And again, because the key finding connects the committee to the definition of a local board, it was clear when you look at the records that the resolution that was adopted did not fit the requirements of the municipal act or the requirements that are set out in your procedural bylaw in this case. And that's probably a product of history of how the committee functioned more than anything else. I would not deem it to be a deliberate act. I would call it a sin of omission, not a sin of commission. Just to be clear. Just to be absolutely clear about that. The reasons that were cited in the record, just to conclude here, in my opinion, clearly did not meet the exemptions that would have been permitted under the Act. There was reference to a legal matter, which again had no bearing on the topic that I could find in the record. There was also an interesting reference, though, to provincial funding, a funding issue, and that had certain sensitivities, including the fact that there was a provincial election underway at the time. Again, in my view, while I understand and acknowledge that that's always a factor, in my view, this was an exploratory meeting. This was an engagement of the parties for the first time to begin to explore partnerships, funding partnerships, and that sort of thing. And in my view, there could have been a discussion about funding without compromising the public disclosure requirements that were set out in the agreement to approve the actual funding from a senior government agency. I think at least a reference to the fact that funding from a senior agency had been secured to assist with the project could have been made public without in any way damaging or compromising the city with respect to the requirements for the funding in that case, or the committee, or the delegation that actually was responsible for securing the funding. So from my chair, I think it could have been handled that way. Now, the last point that was raised in the complaint was what persons permitted to attend. It was felt that was not proper. The fact of the matter is there is no standard, there is no practical set of rules with who attends and who does not attend. The subject matter at hand determines who attends, and normally, as a matter of practice, those who attend are usually identified by either the clerk and or the presiding officer. In the case of council, it would be the mayor, or if it was a committee, it would be the committee chairperson. That's a standard. And so I found nothing unusual about an individual finding themselves in that meeting based on that standard practice. And I just wanted to be clear about that as well. The recommendation in the end, I did slip in, and this is a nasty habit of mine, a rise and report, purely a procedural practice that I like to cite, just a reminder that when any group is required to go into, is permitted to go into a closed session, it's such a great practice to come out and just give a rise and report on the general proceedings of what happened in there, and I just couldn't let that pass. And I hope I didn't offend anybody with that piece. The recommendation in the end, while it sounds simple, and it's all about really just convening a series of meetings so that committee chairpersons and their respective staff resources have an opportunity to be acquainted and with the provisions of the Act and the general requirements of how you procedures that would be required to propose a meeting to the public if that particular committee, and I want to underline that, is in fact subject to Section 239. And so, and I've also suggested that the timing for this training take place when there are new committee appointments taking place as well, and that sort of thing. There is a bit of hard work, though, and I had just a bit of a short discussion over the telephone with your clerk. Ms. Finn has commenced some work, which I understand council has authorized to do, which I'm really pleased to hear. That work is going to take a bit of time in sort of sifting through the committees and the committee structures to make sure that city staff, city council, and the public are aware of who actually is subject to the regulations and who is not. And that's a task that's going to take a little bit of work. I have said to Ms. Finn that if available, I'm quite happy to assist without any charge from the point of view of a consultant's fee. I find this topic rather fascinating and not an easy one, and I think that if I can assist the city in any way in this regard, I'd be happy to do it. Mr. Mayor and members of council, that's sort of a quick summary distillation of the report and the findings, and I'd be very pleased to answer any